Welcome. This is our periodic Tech Law 10, where the law and technology meet. And Jonathan Armstrong and I, this is Eric Sinrod from Dwayne Morris. We've been doing this now for quite a few years, first in the audio podcast realm and now in the video podcast realm. And today I'm reading Jonathan's mind, and I believe he's going to tell us about all things data transfer.
Yeah, thanks very much, Eric. And I think this is a hot topic. As you know, I've been on a mini lecture tour of the US for the past 3 weeks or so. It's certainly a hot topic amongst the people I've spoken to in the US. Almost the majority of questions, I think, were around data transfer this time round. And certainly it's a hot topic over here in Europe. So what's this about? Well, effectively, it's our good old friends, Safe Harbor and Privacy Shield. So for recap, for anybody who's not followed the history of this, in 2000, the European Commission agreed a data transfer deal with the US. And as another recap, under data protection or pre-GDPR and post, you have to have a lawful means of data transfer to move data from the EU to the US. And that could be consent, it could be something called standard contractual clauses, a sort of form agreement, or it could, in 2000, be safe harbor. But in 2010, there were some doubts expressed about whether safe harbor was in fact safe, and in part, whether the US authorities were doing enough to enforce the safe harbor regime. There was a report called the Galexia report by a US-based consultancy, and that was latched onto by one German data protection regulator, a guy called Thilo Weikert, who then persuaded a body of German data protection regulators called the Düsseldorfer Kreis that they would look critically at some of the findings in the Galexia study. So that effectively made safe harbor wobble, but what struck the hammer blow was Max Schrems challenging Facebook's transfer of data from the EU to the US, which led to a decision of the ECJ in 2015 that effectively struck safe harbor down. And the European Commissioner then, I guess, applied what we call the Chumbawamba test. It wasn't how far they got knocked down, but whether they got back up again. And they got back up again with a Privacy Shield, which replaced Safe Harbor and was a similar deal to Safe Harbor, but with some bells and whistles. When I interviewed Max Schrems about it, he called it Safe Harbor with flowers on it. And that's not a bad description, I think. It didn't address wholeheartedly the problems that the ECJ had outlined in the 2015 decision. And then in 2020, Privacy Shield followed its parent, if you like, and was also struck down by the ECJ. So the announcements that we just had in October were effectively for a replacement deal called the Data Privacy or Data Protection Framework. We'll just call it DPF. And they effectively are another new deal between the European Commission and the US. And it is proposed that President Biden do this by executive order and effectively do three things. First of all, have a civil liberties protection officer. Now, one of the changes between Safe Harbor and Privacy Shield was a ombudsman who would look at complaints from EU nationals. The ombudsman proposal had a bit of a torrid time, which I think it would be TechLaw 110 if we went into that whole history. But suffice to say, the ombudsman scheme didn't go down very well. and this Civil Liberties Protection Officer is another bash at that, if you like. There's to be a data protection review court, and I've got a question for you in a minute, Eric, to give you advanced warning. There'll be effectively a directive to the US security services that they should only process data which is necessary and proportionate. That's partly to reflect GDPR and partly to reflect concerns from the ECJ, the court. And the fourth step is that US agencies, and we're mostly talking about security services here, will have a policy and process review to try and abide by the spirit of EU data protection law. So it's proposed that this will be an executive order, obviously, rather than federal legislation, which we've discussed earlier. And that means that there may well be a rocky road for the proposals. In terms of time frame, my best guess is sometime spring 2023. There's a bit of process to go through in terms of a sort of mini consultation at an EU level. But before that can take place, there has to be effectively a draft order, a draft adequacy decision, which the consultation will be around. And what of the dreaded B word Brexit? Well, the UK effectively is going to do more or less the same deal. There should be less process behind the UK doing a deal versus the EU. So it could be that there'll be an element of asynchronicity, that the UK minister might announce that she's ready for a UK-US deal sooner than the Commission is ready for an EU-US deal. But in any event, I think, as I say, realistically, I think we're looking at sometime 2023. Is there any certainty is the question that I was asked the most on my mini US tour. And unfortunately, I think the answer is no. I think this deal will be challenged. It may be challenged by Max Schrems and his pressure group NOYB, who have said that they will probably challenge it. They'll obviously look at the adequacy decision first, I would think. There are a number of other pressure groups, Digital Rights Ireland, La Quadrature du Net, who challenged or sought to challenge a privacy shield. I think they will likely appear again, and there's some other candidates for that as well. So I think it will be something that will be very much attacked, and I think there will be attempts to stab DPF in the back, but also in the front as well. I think it will be a scheme that will be criticised. I think one of the criticisms will be that this is done by executive order rather than by federal legislation in the US. And the other criticism that I'm picking up quite a lot is that the Data Protection Review Court isn't really a court at all. And, you know, you can take a white horse and paint black stripes on it, but it doesn't become a zebra just because you call it a zebra. And I think there's the same criticism of this adjudication body, let's call it that if it really is an adjudication body or a administrative tribunal, calling it a court doesn't fix the problems that the ECJ had with the last two schemes. And I don't know whether you had any thoughts from a US perspective as to whether any of those criticisms might be well-founded.
Well, thank you, Jonathan. And that was a good summary. First of all, I want to thank you for touring the US. You took the US by storm like the Beatles did in the 1960s. So well done. You know, across our several hundred podcasts and video podcasts, I think the name Max Schrems has come up more than any other individual. Don't you agree?
I think you're right.
I mean, dozens of times, and for good reason. And honestly, Schrems himself has pointed out some concerns about this data protection review court because it's a creation of our executive branch. And he's voiced concern that potentially a court, this is not your father's standard court, as we would say, might not be able to offer real redress that you might get from a judicial court as otherwise usually established in the United States, whether that be access to evidence, the option to appeal a decision, having your case even heard by an impartial judge, because query whether there's a potential conflict of interest between an executive branch created court adjudicating challenges relating to executive branch agency actions. I see you nodding your head, so there's some resonance there. But then we get to the fundamental question, whatever relief you might or might not be able to get from this, as you call it, zebra, we would call zebra, is it even a properly created court? Now, we do have precedent for creating, excuse me, specialized federal courts in the US pursuant to Congress's power under Article 3, Section 1 of our Constitution, which authorizes the creation of, quote, inferior courts as the Congress may from time to time ordain and establish, close quote. And examples of such courts include the U.S. Court of International Trade and the Foreign Intelligence Surveillance Court. But those were created by Congress, not by executive order from the executive branch. So I don't know. Now, if properly created and designed, maybe, perhaps, such a court could address many of the concerns raised in opposition, for example, to a private right of action, permitting some limited discovery and motion practice, conceivably requiring aggressive timelines and expedited hearing schedules, and allowing consideration of legal issues by a judge in judge trial. But again, that remains to be seen. I mean, this is early days, right? I mean, this executive order was executed just on October 7th, little more than a month ago. And then one wonders whether and how this court would deal with potential class action lawsuits. But I do believe if such a zebra sought to limit attorneys' fees or even prohibit class actions, there could be quite an outcry here by plaintiff class action attorneys. So I'm not sure we can really, nail this one down with any precision yet. I offer some, issues to consider and ponder about. But given what I just threw out, what are your thoughts now, Jonathan, in response?
Yeah, that does sound really interesting. My gut feel is that the zebra is intended to adjudicate complaints between EU/UK citizens or those who have GDPR rights versus US government. And of course, any corporation that signs up to DPF presumably still has the potential for a class action against it in a normal court because it's breached the conditions of DPF. For example, it's made promises, public statements that it complies with the DPF principles and doesn't, just as we had that threatened litigation over safe harbor, both in the EU and in the UK. I think there's still at least one case rumbling on through the German courts on that. And then presumably the plan is that the Federal Trade Commission will also discipline people who make false statements to procure DPF membership, because it's still going to be an opt-in scheme. And we would expect that maybe 1,500, maybe 2,000 corporations would opt into the DPF, but it's not mandatory. So it'll only offer protection to the minority of US corporations rather than the majority, I think.
Good points. Yeah.
Maybe a limited scheme. I suspect we'll return to this maybe in spring 2023, maybe in I don't know, October 2024, when the ECJ gets to hear its challenge to the scheme if everything does run to track, because I suspect the challenge is inevitable. But I guess the bad news for those corporations watching is, I think we're both saying that the path of this a new proposal is not going to be smooth, and it's not without its bumps in the road, and it probably doesn't create the certainty that businesses crave.
That's exactly right. If we're looking for tremendous clarity, I'm not sure we have it, at least yet. And I want to point out, in terms of my virtual background, you probably think I have something here from Cambridge or the like in your country, but that's actually my law school at the University of Michigan.
And very fine it looks too.
Yeah, but anyhow, zebra,
tomato, tomato. Maybe they should call the whole thing off.
All right then. Well, thank you very much. I'm Eric Sinrod from Duane Morris. My email address is ejsinrod@duanemorris.com. Jonathan?
I'm Jonathan Armstrong, jonathan.armstrong@caudrycompliance.com. We'll post this as usual on the TechLaw10 LinkedIn group. Do join us there. Comment if you like. If you've got any thoughts about things we should cover in future podcasts, just drop either of us a line. Thanks for watching, and we look forward to speaking to you again in a few weeks' time.
Okay, thank you. Cheers.
Cheers. Bye now.